Hello everyone, welcome to Arth IAS. I am Amit Kumar. Dear students, in this video, we are going to explain Polity section of GS paper 1 of UPSC Prelims 2025. So, let's start. Before starting the explanation, I would like to tell you that this year, in 2025, there were 14 questions, exactly 14 questions from Polity section. Last year, in 2024, there were 18 questions. So you can see the number of questions as comparison to last year has been reduced, but you can see the average range of polity section in prelims every year is between this 12 to 18, right? And this year 14 questions directly from core polity section. So you can say it has a good number of weightage, right? Now let's start. One more important thing I would like to tell you that you must watch these two videos that I have uploaded few days before prelims. In this video, I have mentioned all the important topics that is relevant from prelims 2025 or even in upcoming years. Right? Most means the topics here means mentioned in this video are very important, and UPSC asks questions in prelims from these topics. So you should watch this video. Next, just as I told you, I think 10 days ago of prelims, I had made a separate video on pardoning power of president versus governor, and I had covered this topic holistically. It is a 56 minutes video, and this year in 2025, there is a question from this section of pardoning power of president. So again, you must watch this video. Now let's start. So first question is about the creation, or you can say timeline of states, right? So first says, consider the following pairs. State description. Arunachal Pradesh. The capital is named after a fort, and the state has two national parks. Generally, this statement can be correlated with the geography, right? And I think most of the students would or didn't know about this statement, right? Except few. So, but this statement is correct. Why? The capital of Arunachal Pradesh is Itanagar, and it has been named after a fort known as Ita Fort. And again, it has two national parks. So this statement is, as I told you, correct. Next, Nagaland. The state came into existence on the basis of a constitutional amendment act. It does not say with constitutional amendment act. It simply says by constitutional amendment act. Then you must be knowing that under 13th constitutional amendment act, which year 1962, it became 16th state of India. So obviously this is also correct, this is also correct. Now third, Tripura, initially a part C state, obviously, right? After independence, states were categorized in certain categories, part A, B, C, D, right? And Tripura was under or initially a part C state. Again, it became a centrally administered territory, means union territory, with the reorganization of states, obviously reorganization of a state act 1956. Later attained the status of a full-fledged state, also correct. So you can clearly see all the three are correctly matched, right? Go for option C. C is the right answer. Here is the explanation, you can read. Now, second question. This is related with fifth schedule. So it simply says, consider the following statements. With reference to the Constitution of India, if an area of a state is declared as scheduled area under fifth schedule, then first statement, the state government loses its executive power in such area and a local body assumes total administration. No, there is no provision like that. So this statement is wrong. Second, the union government can take over the total administration of such area under certain circumstances on the recommendation of the governor. Yes, only on the recommendation of governor, the union government can take over the administration of such area. But there are conditions, and it should be recommended by the governor, right? So this statement is correct. So you can clearly see only second statement is correct. Option B is the right answer. Now third statement, very straightforward statement, right? And here you will see that what is the importance of previous year question paper, right? What happened that in 2020 this was a question in prelims 2020, right? It says, simply says, consider the following pairs provision in the constitution of India and stated under. First statement says separation of judiciary from the executive in the public services of a state. This was a question in 2020. Again this year this has repeated, this has been repeated, right? So you must be knowing under article 50, right? And what is it? It is a directive principle of state policy. So this statement is correct. Article 50 simply says separation of judiciary from executive. The state shall ensure separation of judiciary from executive. So this is correct. Second, valuing and preserving of the rich heritage of our composite culture. Fundamental duties, obviously, also correct. Which article? Article, as you will be knowing, under article 51A, fundamental duties have been given, and this duty especially mentioned under clause F. So this is also correct. Now third, prohibition of employment of children below age of 14 years in factories. Obviously very simple. Which article? Article 24. So this is also correct. So you can clearly see that three topics has been given in one question. DPSP, fundamental rights, fundamental duties. So you can clearly see all the three statements are correct. This is correct, this is correct, this is correct. So correctly matched, go for option C, right? It does not require further explanation. Now next question related with Speaker of Lok Sabha. It says consider the following statements, right? Again from prelims and mains perspective, Speaker of Speaker, Deputy Speaker, and Chairman and Deputy Chairman, all are important from prelims as well as mains perspective. And see, question is from Speaker, right? It says on the dissolution of the House of the People, means Lok Sabha, the Speaker shall not vacate his or her office until immediately before the first meeting of the House of the People after the dissolution. Obviously correct. What happened that even the Lok Sabha or House of the People has been dissolved, but the Speaker does not vacate his or her office until the first meeting, right, is held and new or pro tem Speaker has been elected. Only then the Speaker vacates his or her office. So this is correct. Second, according to the provisions of Constitution of India, a member of the House of People being elected as Speaker shall resign from his or her political party immediately. No, it is nowhere written in the Constitution nor practiced in India. In India, simply Speaker of House of People is supposed to be politically neutral, unbiased. It is a parliamentary convention in Britain, right? This is a parliamentary convention in Britain that is followed. Means if a member in lower house of Britain is appointed as, means elected as Speaker, then that person resigns from his or her political party. But in India it is not followed. Neither it is written in the Constitution nor it is followed. So this statement is wrong. Third, Speaker of the House of the People may be removed from his or her office by a resolution, obviously, of the House of the People passed by a majority of all the then members. Majority of all the then members means effective majority of the House, provided that no resolution shall be moved unless at least 14 days notice. Yes, prior notice of 14 days must be given to the Speaker that a resolution is going to be passed against you, right? Has been given of the intention to move the resolution. So this is correct. So you can clearly see statement 1 and 3 are correct, 2 is incorrect. So here you can apply elimination method. 2 is correct here, 2 is incorrect. So 2 here, 2 here, 2 also here. So not this, not this, not this. C is the right answer. 1 and 3 are correct. Here is the explanation, you can read. Now, next. This is related with amendment of the constitution. It simply says, consider the following subjects under the Constitution of India. List 1, Union list in the 7th schedule, extent of the executive power of state, condition of governor's office. Right? Now, for a constitutional amendment with respect to which of the above, this or this, ratification by the legislature of not less than one half of a state is required before presenting the bill to the President of India for assent. Right? Simply, it asks that to amend which of the above subject requires ratification by not less than half of total number of state legislature before presenting it to the President for his assent. So, this also requires, but this does not require ratification by the half of the legislatures of a state. So, simply 1 and 2 are correct, go for A. Here also you can use elimination technique, 3 not, 3 not, 3 not. Only 1 and 2 are correct. Here is the explanation, you can read. And here certain subjects are there which requires ratification. Now, again, this question is little bit tricky question. Why? When we will read second option, we will see. It says, consider the following statements. If any question arises as to whether a member of the House of the People has become subject to disqualification under 10th schedule, anti-defection law, President's decision in accordance with the opinion of Council of Union Ministers shall be final. Here, this is wrong. Not President's decision. If a matter related with disqualification of members under 10th schedule, then if it is Lok Sabha, then Speaker's decision is final, right? And if it is Rajya Sabha, then Chairman's decision is final, right? Not President. So this statement is absolutely incorrect. Next, there is no mention of word political party in the Constitution of India. If you simply read the statement, you will think that it is correct, but no. Why? Let me tell you. It says no mention of word political party in the Constitution of India, but under 10th schedule, word political party has been mentioned, right? And 10th schedule is part of Constitution of India. So in that sense, this statement is also incorrect, because it says no mention of word political party in the Constitution of India, but 10th schedule, which is part of Constitution of India, is or mentions word political party several times. So in that sense, it is also incorrect. So option D is the right answer. So no need of further explanation. Now, 7th number question. As I told you that there is a separate video on pardoning power I had made just before few days of prelims. You must watch that video, right? I will give the link in the description box. Now read the question. You can easily answer this question after watching that video, right? So it says, consider the following statements with regard to pardoning power of the President of India. So the exercise of this power by President can be subject to limited judicial review. Yes, if the President, for example, in several cases, Supreme Court has upheld that this is means pardoning power of President is subject to limited judicial review. In general sense, it cannot interfere, but it has limited judicial review. Why? For example, if the President has used the pardoning power in with malafide intention or politically motivated, or he has or she has ignored the important facts, then there is limited judicial review. So this statement is correct. Second, the President can exercise this power without the advice of central government. No, absolutely incorrect. The President can exercise this power or pardoning power only with the advice of the central government, that is Council of Ministers. So this statement is incorrect. You can clearly see only first statement is correct. A is the right answer. Here is the explanation. You can read. Now, Eighth number question. It is related with ordinance, and you must be knowing under Article 123, President can promulgate ordinance. Under Article 213, the Governor of a state can promulgate ordinance. So it says, with reference to the Indian polity, consider the following statements. An ordinance can amend any central act, right? As you do know that ordinance has same effect just like any other ordinary law. So just like any an ordinary law can amend a central act, so in that sense ordinance can also amend any central act. This is correct. Next, ordinance can abridge a fundamental right. As I told you, it has same effect just like any ordinary law, and if there is a clash between ordinary law and fundamental rights, then fundamental rights shall prevail. So ordinance cannot abridge a fundamental right. It requires constitutional amendment, right? So this statement is wrong, incorrect. Third, an ordinance can come into effect from a backdate. Obviously, very straightforward statement. So you can again here apply elimination technique. Second statement is incorrect. See, second statement incorrect. See, second statement incorrect. Also second statement incorrect. So C is the right answer. Here is the explanation. You can read. Now, ninth number question. The Constitution of India explicitly mentions that in certain sphere, the governor of a state acts in his or her own discretion. Obviously, for example, if it is related with Article 200, assent to the bill passed by state legislature, then the governor can use his or her own discretionary power to reserve the bill for the consideration of the President of India. Again, if it is related with Article 356, President suit, again he can use his or her own discretionary power. Again, if it is related with fifth schedule, again governor can use discretionary power. So this is correct. Now, the President of India can, of his or her own, reserve a bill passed by state legislature for his or her consideration without it is being forwarded by governor of state concerned. Incorrect. It is against the concept of federalism. If a bill has been passed by the state legislature and it is directly forwarded to the president, ignoring the governor, it is against the concept of federalism. And what is the importance of governor then? Why? Governor has been appointed. So this statement is incorrect. Right? Only one is correct, means A is the option A is the right answer. Here is the explanation. You can pause the video and you can read. Next, 10th number question. Again, so this year UPSC has given so many questions from governor and president combined. And every year you can see that even in previous years or even in upcoming years, governor president topic is very important. So it says, with reference to Indian polity, consider the following statements. Governor of a state is not answerable to any court for the exercise and performance of the powers and duties of his or her office. Very general statement, and we all know that, right? Under which article? Article 361, clause 1. Immunities to governor of a state. Second, no criminal proceedings shall be instituted or continued against the governor during his term or his or her term of office. Obviously, again, straightforward statement under article 361 clause 2. Also correct. Next, members of state legislature are not liable to any proceedings in any court in respect of anything said within the house. Obviously, these are privileges given to legislators. Same condition applies with the members of parliament. They cannot be or they are not liable to any proceeding in any court, whatever they have said. Right? And this is covered under which article? Article 194. Which clause? Clause 2. Clause 2. So this is also correct. You can clearly see all the statements are correct. So go for option D. Here is the explanation. You can read. Now 11th question. This question can be called as a little bit or moderate to tough level question. Like generally students do not read such type of acts. Mines, this is related with Mines and Minerals Act 1957. Right. So it says consider the following statements. Statement 1. In India, state governments have no power. It says no power for making rules for grant of concessions in respect of extraction of minor minerals. Minor minerals, for example, sand, rocks. These are minor minerals. Even though such minerals are located in their territories. No. In case of minor minerals, state government has power making regarding making rules for their concession in respect of extraction. Right? So this statement is incorrect. Simply you should know that state government can make rules regarding extraction of minor minerals. Second, in India, the central government has power to notify minor minerals. Notify. Right? It can notify which minerals are minor minerals or not under the relevant law. Obviously, this is correct. So, D is the right answer. It says statement 1 is not correct, but statement 2 is correct. So, D is the right answer. Here is the explanation. You can read. Now, 12th question related with panchayats. It simply says, consider the following statements. Panchayats at the intermediate level exist in all states. No. Basically, it depends on the population of the state, right? Administration of the state. So, panchayat at intermediate level does not exist in all the states. This statement is incorrect. Be careful when you find statement word like all, only, none. Right? These are tricky words used by UPSC. It plays with your mind. Next, to be eligible to become a member of a panchayat at intermediate level, a person should attain the age of 30 years. No, it is just 21 years. Also incorrect. Second, last statement. The chief minister of a state constitutes a commission to review the financial position of panchayats at intermediate level and to make recommendation regarding the distribution of net proceeds of taxes and duties leviable by state between the state and panchayat at the intermediate level. So this is talking about commission. Which commission? State Finance Commission. State Finance Commission. So you must be knowing that State Finance Commission is constituted by whom? The governor of the state. And statement says chief minister. So again, this statement is incorrect. Right? All the three statements are incorrect. It says which of the statements given above are not correct. All the three statements are not correct. Go for option D. Here is the explanation. You can read. Now, 13th number question related with Lokpal. This question is little bit confusing question. One option is little bit confusing. Right? So, it says, consider the following statements about Lokpal. The power of Lokpal applies to public servants of India, but not Indian public servants posted outside India. No. If you are a public servant, whether you are serving inside India or outside India, you are covered under Lokpal. So this statement is incorrect. Second, the chairperson or member shall not be a member of parliament or member of legislature of any state or union territory, and only, right, be careful, only Chief Justice of India, whether incumbent or retired, has to be its chairperson. No. Though Chief Justice of India, whether retired or incumbent, can be its chairperson, but any other person who has knowledge, experience regarding public service, who is man of honesty, integrity, can be its chairperson. So this statement is again incorrect. Now, third option is, or third statement is little bit, you can say, confusing. Why? It says the chairperson or a member shall not be a person less than 45 years of age on the date of assuming office as the chairperson or member, as the case may be. Listen, take reference. I have taken reference of two sections, section 3 and section 4 of Lokpal Act 2013, right? And 3 talks about the qualification for chairperson and members of Lokpal. 4 talks about disqualification of chairperson and members of Lokpal. But nowhere it is mentioned that or age criteria has been mentioned. Nowhere, whether it is section 4 or 3. Right? It simply says that the person should have 25 years experience. 25 years experience. Not explicitly mentions 45 years age. So in that sense, if someone says that this statement is correct, then it is his or her personal opinion. But I am referring to sections, section 3 and 4. You can go and check. Never or nowhere it is mentioned 45 years. Simply 25 years experience is mentioned. And if you consider this experience, then obviously the person would be around 50 or 50 plus. But explicitly the age of 45 years is nowhere mentioned. So again, I am considering this statement is incorrect. Last, fourth statement, Lokpal cannot inquire into allegations of corruption against the sitting Prime Minister of India. No. There are reasonable restrictions. For example, national security, if matter related with national security, then it can be exception. But generally, if it is a sitting Prime Minister, then and there is allegation against him for corruption, then Lokpal can inquire against a sitting Prime Minister regarding corruption. So again, this statement is also incorrect. Now it says, which of the statement given above is or are correct? Option D is the right answer. As I told you, why only this statement is confusing, and I have clarified that. Right? So D is the right answer. None of the above statement is correct. Now last statement. Here is full explanation is given. As I told you, you can read. Now we will see the last question, and it is related with constitutional bodies. So it says, with reference to India, consider the following. First, Interstate Council. Second, National Security Council. And third, Zonal Councils. It says, how many of the above were established as per the provisions of the Constitution of India? Simple. So, if you have read constitutional body, you must be knowing that Interstate Council is created under the provision of Constitution of India. So, this is correct. Second, National Security Council, no. Zonal Council, also no. Under constitutional provisions, right? Though it is indirectly created, means there, but there is no direct provision of zonal councils in the Constitution. No direct or explicitly mentioned. So only one is correct, Interstate Council, right? So A is the right answer. You can check the explanation. Here is the explanation, as I told you. Interstate Council, right? Under Article 263, National Security Council is a body advises Prime Minister on matters of national security and strategic interest, established in 1998, right, by executive order. Simple. And lastly, Zonal Councils. Why? Because created under State Reorganization Act 1956, and what it is a statutory, you can say, or statute or law, and not explicitly mentioned in the Constitution of India, right? So this was all about the explanation of polity section of Prelims 2025. We will meet in another lecture. Thank you for watching.